In this installment of Washington Legal Foundation's Legally Brief, Patrick Rowan, a partner with the law firm McGuire Woods, will share his thoughts about the outcome of a federal foreign bribery investigation and prosecution involving U.S. medical device manufacturer Biomet. Now, the Biomet investigation arose from a broader targeted DOJ and SEC focus on healthcare product manufacturers' business practices overseas under the Foreign Corrupt Practices Act. Mr. Rowan, can you tell us a little about those targeted efforts and why officials are focusing on healthcare product makers?
Well, the Biomet investigation represents the coming together of two elements of Foreign Corrupt Practices Act enforcement that we've seen a lot of in recent years. And the first is the idea of industry sweeps. The government, once it comes to understand that bribes are commonplace in a particular industry or a market, works their way from company to company in that industry to try to make sure that they're rooting out corruption among all the businesses. In this way, the regulators are able to learn the business and understand it. And also in the course of these investigations, they put pressure on the companies involved to provide information about their competitors. And when all's said and done, you have a record of having gone after 3 or 4 or 5 businesses in a particular industry. And in doing that, deterring others from being involved in Foreign Corrupt Practices Act violations. Now, one industry that has been the subject of terrific focus in recent years is the healthcare industry. The makers of medical devices, the pharmaceutical manufacturers, have been the target of a great deal of enforcement by the United States in recent years. In part, this is because the companies involved all are, when they're operating overseas, in some countries, these companies are basically dealing with government employees almost exclusively. If the country involved has a state-run medical service, then the doctors, the nurses, the hospital administrators are all considered foreign officials for purposes of the FCPA. The FCPA targets foreign officials and defines it in a broad way as including employees of a foreign government, including employees of an instrumentality of a foreign government. So all those healthcare employees in countries where the state runs the medical business are going to be considered foreign officials. And if they're involved in receiving bribes for using particular products, particular pharmaceutical products or medical devices, then that's going to be considered a Foreign Corrupt Practices Act violation. And it's also coupled with the fact that in many countries, these doctors and nurses don't get paid particularly well, and getting commissions or bribes, kickbacks, whatever you want to call it, has been a relatively common practice in recent years, and they're used to it. And it's hard for companies who go into those markets to feel that they can compete unless they're doing this kind of thing themselves. So the healthcare industry as a whole has been the subject of a great deal of enforcement interest by the United States. They've come to understand that these practices are common overseas, and they've worked their way through a number of companies. Biomet is the third large settlement in the last year involving an American medical device manufacturer, and they agreed to pay $22 million to the Department of Justice and the SEC in connection with bribes that were provided to doctors in Brazil, in Argentina, and in China.
What foreign business conduct got Biomet particularly into trouble, and what role did breakdowns in the company's corporate compliance efforts play in their being pursued by DOJ and SEC?
According to the agreements that the company entered into with DOJ and SEC, there were employees of the subsidiaries of Biomet who were paying commissions to doctors in Brazil and Argentina and China, 10 to 15% of the cost of the product for every instance in which the products were used. Biomet makes hip replacement devices and other significant medical devices. And so these doctors were receiving commissions for their use of these devices. It's a clear kickback that violates the FCPA. In addition, there was a record that, particularly in China, that Biomet's representatives were paying for foreign travel for Chinese doctors that was much more about entertaining them than it was about promoting their product. And the other thing that jumps out at one from the documents is that as early as the year 2000, executives and internal auditors at Biomet's headquarters here in the United States were aware of at least some of these payments, and yet they didn't stop until 2008 or 2009. So the internal structure for finding these problems and fixing them didn't work.
Can any specific lessons be learned from the deferred prosecution agreement that DOJ entered into with Biomet, as well as from the public statements made by SEC for healthcare and other companies with FCPA concerns?
Well, this agreement reiterates to anybody in the healthcare business that they are right in the crosshairs, and they need to be very careful in how they conduct their business overseas. If there are problems, they can't overlook them. They need to dig into them and make a very clear and realistic determination about whether or not they need to self-disclose those practices. And they certainly have to fix them. And that's the bigger point, I think, for anybody who has exposure to FCPA overseas, is that when your compliance staff, your internal auditors, they need to be robust enough in the way they do their business to find problems, and they need to be empowered to fix them, and they must be required to fix them, because it's almost worse to have a compliance function and find problems and not fix them than it is to not find them at all, because the SEC and the DOJ expect that a company of this size will understand what their obligations are under the FCPA and do what has to be done. So any company that's involved in overseas business that may have exposure under the Foreign Corrupt Practices Act has to be sure that its compliance and its audit function is doing everything it can to stop any problems that it finds.
Mr. Rowan and his colleague Alex Brackett from McGuire Woods authored a working paper for Washington Legal Foundation on federal anti-corruption officials' focus on the medical device and pharmaceutical industries that is available at WLF's website, www.wlf.org.